Hello and welcome to Williams Mullins Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Bryden DeWitt, and today I'm joined by a longtime friend of this podcast, Burl Ball, Principal Financial Advisor at CapTrust. Thanks for coming back, Burl.
I am so glad to be here again, Bryden. Thank you.
Well, Burl, today we're talking about something that when we first picked this topic, we didn't know how hot of a topic it would be at the time of this recording: alternative investments in defined contribution plans. As most listeners probably are aware, we've recently had an executive order from President Trump trying to open the way, I suppose, for 401k plans and defined contribution plans, ERISA plans, to invest in alternative investments. And kind of like so many things between the first Trump administration, the Biden administration, and the second Trump administration, alternative investments such as private equity, private debt, private real estate, cryptocurrency, it's been like a ping pong ball, kind of like ESG has gone back and forth with the two administrations. In the first Trump administration, there was a Department of Labor information letter that indicated that investing in private equity would not violate ERISA. Then under the Biden administration, we received guidance from the Department of Labor warning plan fiduciaries to exercise extreme caution when evaluating the use of alternative investments such as private equity and cryptocurrency. It didn't go so far as regulatory guidance, but the Department of Labor was just letting everyone know at the time that they viewed these types of investments as being of, I guess, particular concern and requiring special scrutiny if plan fiduciaries were thinking about including them in their investment lineups. And then just, I guess, last week, from the time of recording this podcast, Donald Trump issued an executive order encouraging the Department of Labor to basically ease restrictions or facilitate the use of private equity, cryptocurrency, alternative investments under 401k plans, defined contribution plans, ERISA plans. And my initial reaction when I saw the news hit my news feed was, an executive order doesn't change the facts, right? I mean, plan fiduciaries still have to evaluate each type of investment they want to offer under a plan pursuant to their ERISA fiduciary duties of prudence and loyalty to plan participants. And so an executive order does not make these types of investments any less risky simply because we have an executive order. But the order itself, however, directed the Department of Labor to potentially issue safe harbor regulatory guidance for the selection of alternative assets, alternative types of investments. And I think if that occurred, then that would be a game changer as far as allowing plan fiduciaries to feel some sense of comfort of offering these types of investments. And I imagine with all of the attention here on these alternative investments that employers may start to feel pressure from employees, from plan participants, to allow them to invest their 401k assets into these types of investments. So we've seen a lot of changes over the last 5 years regarding alternative investments. And so, Burl, that's a long intro, but what is a plan sponsor supposed to do here sitting in August of 2025?
First, I think, Bryden, what I would want a plan sponsor to do is to take a little bit of time and figure out what these alternative investments are all about, especially if you're a plan sponsor for a 401k plan or any other kind of defined contribution plan. Alternative investments have actually been around for a very long time. They've been used in defined benefit plans. For those who have endowments or foundations, they've been used there. We put into those kinds of plans maybe 10 to 20% in alternatives. And I'll use that general category alternatives to describe private equity, private debt, private real estate. And those were out there for a much longer time, of course, than cryptocurrency, which is much newer on the horizon. But the reason that the other kinds of plans were able to do that and do it well is that they were looking for diversifying assets. So instead of the traditional mutual funds or CITs today, they were looking for ways to have investments that would not follow the traditional stock market or bond market that you would see in a defined benefit plan or an endowment and foundation. So we know some things about these kinds of investments because of that. But as you said earlier, we've not been in a position of having them in 401k plans. And we also have some issues around these that are unique to what happens in 401k plans that don't happen in defined benefit plans or endowments and foundations. For example, in alternatives like this, we don't always get pricing information on a daily basis. We're very used to that in 401ks when we look at mutual funds and even in CITs. We've got all kinds of investments that we know can be daily priced. We also know that often those alternatives cost more. So fees are higher. And how do you assess fees? Information about performance isn't transparent. We're not able to really understand what exactly is in all of those investments. So those are the things that would help plan sponsors understand better how they work. What are the costs? What's transparent? And in addition to fees, what can we say about liquidity? Can people get their money out? Those have all been the things that have kept alternatives out of 401k plans.
Really, there's no change.
There is not.
The reason these types of investments have not been in 401k plans are for the reasons you just outlined. And even if we get regulatory guidance, certainly this executive order by itself, I'm concerned some plan sponsors may think, well, now we can offer, there's this executive order and now we can offer these alternative investments. Well, no, all of these considerations are still there. Like the facts haven't changed.
They have not about the alternatives. What has changed, though, is really two things. The first is there are fewer and fewer public companies in the US. About 50% of the companies now are private. If you think about it, we've seen less and less IPOs over the last few years where private companies are going public. So there's this whole group of investors in private companies or private, in this case, private real estate that really hasn't been part of the opportunity for people to invest. And if you read the executive order, it talks about modernizing investments. And part of that is access to parts of the market that really haven't been there and have grown a lot. The other part of it is all of those investments can look to 401k plans, which now make up $12.5 trillion in assets open to investments. And wouldn't organizations who do private real estate and private equity and so on be interested? It's kind of the last best way for those organizations to find investors is to look at 401k plans, and that's trillions of dollars with a T. So very, very interested. So how might they go about doing this? Well, we've actually seen some alternatives in different kinds of funds. For example, most companies offer target date funds. In fact, they're the largest investment. So we do know that there are target date funds that have put into the makeup of their assets alternatives. Alternatives do exist in target date funds today. They also exist in managed accounts. Those are those accounts that record keepers offer for an additional fee for participants to be able to have professional management for their assets. So I think we're going to start seeing, after this executive order, more investment from target date funds and managed accounts in alternative assets versus people investing directly in alternatives and in private equity in cryptocurrency as we go. So how at this point should we assess that? First, learn a lot more than you know now as a plan sponsor about any of these kinds of investments, in plans. Also, we're starting to see record keepers jump into the marketplace. Fidelity, for example, allows folks to have access to cryptocurrency. That's a new fund that they've put out. Just recently, Empower, two of the largest record keepers out there, have put out information about allowing alternative investments. And that was before the executive order. So, but what we know is there are more risks, less liquidity, higher fees, et cetera. So thinking about that, the next opportunity would be, I think, to really go and decide what type of due diligence you want to do. Even if we do have an executive order or that gives us more guidance than we have now, or we even have a safe harbor, as you mentioned, Bryden, we would also want to make sure that we have the same amount of due diligence, even though it may be more difficult, as much due diligence as possible. We still are in the same ERISA world where it's all about documentation and process and not result. So that still exists as what we all need to be thinking about. So I would encourage plan sponsors to talk to their advisors, talk to their legal counsel about this opportunity. I don't think it's going to go away. It may be 180 days before we have anything final, but sooner rather than later in this modernization, thinking about the size of 401k assets, the fact that we have private companies versus public companies, I think that a lot of the orders have been rescinded. Find out what's in your target date fund, what's in your managed account, and exercise the same amount of due diligence you would otherwise.
And perhaps the regulatory guidance that the executive order directs the Department of Labor to issue will provide guidance on that due diligence process. What types of inquiry does a plan fiduciary have to engage in order to provide these types of investments in the plan? And perhaps that would be the safe harbor, is you follow steps A, B, C, and D, and then you have a shield from a claim of a breach of fiduciary duty.
Well, another thing that maybe plan sponsors want to consider too is for those who use a self-directed brokerage option.
Mm-hmm.
I've seen some conversations, especially in mega plans, larger plans, that let's use our self-directed brokerage to allow folks to have cryptocurrency. Right now, most companies keep their self-directed brokerage in publicly traded mutual funds. But as I mentioned, we're seeing record keepers starting to allow cryptocurrency in their self-directed brokerage option. We'll see if that gives us a little more protection, having it in self-directed brokerage versus in the core investment lineup. So waiting for guidance certainly makes sense, but I think in the meantime, good idea to start thinking about it. I think the other thing you may want to start thinking about is how much fiduciary insurance do you have? There's no doubt that there will be liability in some way. We know litigation keeps on. We know there's more and more litigation, especially the larger plans are certainly subject to that. So make sure that your insurance liability coverage is up to date.
Well, and maybe I shouldn't even suggest this, but as you made a really good point about the changing landscape of investments and of publicly traded companies and private equity. I could see at some point a plan participant arguing that the plan fiduciaries didn't modernize, right? As
Agreed.
Perhaps as more plans start, offering these options, if an employer is left behind and just says, we're just going to stick with the tried and true typical investments, traditional investments, and plan participants miss out on these alleged gains they could have had if they could have invested in cryptocurrency or private equity. I could see claims going that way. as well.
I would agree with you. I think that's the new world. I mean, when I was first working here in this field, 401ks only invested in mutual funds. In the last 5 years, we've seen more and more use of CITs to get lower fees and more opportunity to make changes in investments at lower costs. So we may see some of that. We do see even today private real estate, where we invest in an organization that actually buys shopping centers and distribution centers and rental properties and so on. So it's an evolving field. Plan sponsors need to keep up because different investments will be available. And I agree with you. It could be the other way. Instead of taking more risk, did you take not enough risk?
Correct. Right.
To meet the opportunity that's there today. And there'll be lots of opportunities for those who are in that field to try to access that $12.5 trillion.
Right. Well, Burl, thank you so much for coming on the Benefits Companion and discussing this really timely topic. That will wrap up our episode. If listeners have questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.
This podcast contains general, condensed summaries of actual legal matters, statutes, and opinions for informational and educational purposes only. It is not meant to be and should not be construed as legal advice. Listeners with particular needs on specific issues should retain the services of competent counsel. For more information, please visit our website at www.williamsmullen.com or contact any member of our team.